All right.
Hello, welcome to a Keystone Contractor Association webinar. Today's title is What the Supreme Court Ruling in Brown versus City of Oil City Means for Contractors. And we are excited to feature today's speaker, Matthew Erlanger, Senior Counsel for Cohen Seglias. Hopefully I said your name correctly there.
Fairly close, yes. Matt Erlanger.
Erlanger, okay, got it. Matt's a great guy. I'm getting to know more and more. He writes about construction issues, has articles that are featured on Cohen's blog, and he's out and about at industry events. And recently at an event, we were talking about this case, and I had some questions for him, and some other contractors had questions, and Matt said, "Hey, why don't I put a presentation together?" So that's why we're here today. And without further ado, Matt, take it away.
All right, thanks, John, and thanks again for having me. This is an interesting case recently decided by the Pennsylvania Supreme Court that has the potential for sort of wide-ranging implications in the construction industry, as well as other implications in the legal field at large. Before we get started, we just have a few slides here, introductory. Here's some information about me. As John said, I'm a senior counsel at Cohen Seglias. I'm on the construction team focusing on construction litigation. I've been at Cohen for about 10 years and been practicing law now going on 14, representing a lot of contractors and subcontractors throughout Pennsylvania, throughout all of Pennsylvania. And I work out of the Philadelphia and Harrisburg offices for Cohen Seglias, and split my time between those two offices. And here's some information about Cohen Seglias as a firm. We are one of the largest construction law firms in the United States. We represent over 1,300 contractors nationally. We have over 80 attorneys throughout 8 offices. Pennsylvania, we have offices in Harrisburg. We have an office in Pittsburgh. We have an office in Philadelphia, and then we have offices also in New York, Newark, Wilmington, Delaware, Louisville, and a recent office opening in Florida, as well as Washington, D.C. All right, so let's get into this hypothetical. A lot of times in construction, work's completed and there's a defect. The defect isn't discovered right away. It's not discovered until sometime after completion of the project. So we have a new high-rise apartment building. 6 months after it's completed, somebody's walking by, a window happens to fall onto the street and injures the person. It's later discovered that the window fell due to defective work by the contractor installing it. So what's the result? Well, likely that in the litigation that follows, the plaintiff, whether it be the person injured or if unfortunately the person injured dies, the person's estate will name everybody involved in the construction, including the owner, the architect perhaps, and the contractor. And if it's determined that the contractor's installation of the window was defective, well, the contractor could be liable for the injuries. Seems straightforward enough. But let's change this hypothetical. What if both the owner and the contractor knew that the defect existed? And that's sort of the scenario that we're talking about in the recent case of Brown versus the City of Oil City. And there's the Oil City Public Library, which is the construction project that was at issue. So the Oil City Public Library was initially constructed in 1904. So it's 120 or so years old at this point. In around 2009, the city determined that due to weathering over the years, the concrete steps out in front of the library were in need of replacement. So the city goes out, they seek bids and hire the contractor is a company called Fred Burns. They were tasked with removing the old stairs and installing the new stairs, and Structures LLC was the architect that was responsible for the design and construction management. So construction ends around December of 2011. By January 2012, the city discovers that there's problems with the stairs. The concrete is spalling, it's getting cracks. Shortly thereafter, February 2012, the city notifies its architect Structures that the work's defective and that the city regarded it as both as dangerous as well to the general public. Later that year, the city notifies Burns, the contractor, that the work was defective. For whatever reason, even though everyone's aware of the defect in the stairs, nobody did anything. Nobody warns the public. Nobody undertakes to repair the stairs. And reading some of the background, it looks like the city may have had wanted the architect to go out and determine what needed to be corrected, but for whatever reason, nothing further happened, and the condition remained. And as I said, nobody warned the general public. So 3 or so years later, Catherine Brown is exiting the steps of the library with her husband, and she falls on one of the defective areas. And unfortunately, a few days later, this is November 2015, she succumbs to her injuries and dies. So that's the background. And as one would expect, litigation follows. So the husband of Mrs. Brown brings a lawsuit against the city, as well as Burns. Burns joins some others involved in the design and construction later on. The contractors say, this isn't our problem. We turned over the property. The owner's aware of the problem. This is solely an owner issue. And the contractors filed a motion for summary judgment seeking to dismiss the lawsuit, saying they had no duty to third parties. The trial court says, yes, we agree. There's no liability. Case over. Mr. Brown then takes an appeal to the Commonwealth Court, which hears, as the intermediate level court in Pennsylvania, hears appeals of actions involving government agencies generally. And while the case is up on appeal, the city settles with Mr. Brown for $500,000, which is the maximum amount that the city can be liable, because it's a political subdivision and there's a cap on liability of state agencies and political subdivisions in Pennsylvania. So city's out for $500,000. Then we have the appeal to Commonwealth Court. Commonwealth Court disagrees with the trial court and says, no, it doesn't matter if the owner's aware of the dangerous condition. The contractor still has an obligation to third parties for its defective work. The contractors then take an appeal to the Pennsylvania Supreme Court. And really the issue here, it's sort of a technical legal issue. It's about the interpretation of the Restatement Second of Torts, Section 385. Probably not well known to contractors, not all that well known to most lawyers, actually. But what the Restatement Second of Torts, Section 385, and a restatement of torts, there's restatements of contracts, is essentially it's a treatise. It's not the law, but states can adopt or not adopt certain sections of the restatement. In Pennsylvania, the Pennsylvania Supreme Court had previously adopted the restatement second of torts section 385. So this is the law in Pennsylvania as the courts apply it. So what does this say? Restatement second of torts, section 385. There's a lot of words here, but essentially, the implication, so one who on behalf of the possessor of land erects a structure or creates any other condition thereon. That's talking about the contractor. Contractors building a structure on behalf of the owner. So if the contractor builds the structure on behalf of the owner, the contractor is subject to liability to others upon or outside of the land for physical harm caused to them by the dangerous character of the structure. So if the contractor erects the structure and it causes harm to somebody on the land due to the defective work or dangerous character of the work, they're subject to liability under the same rules as those determining the liability of one who, as manufacturer or independent contractor, makes a chattel for the use of others. What does that mean? Well, a chattel is essentially personal property. And sort of a more straightforward way to explain this is, imagine you're buying a car. Say it's a Ford. Ford manufactures the car. Ford then might sell it to a distributor, sells it to the dealership. You then go and purchase the car from the dealership. Generally speaking, if the car is defective and causes an injury either to you or to a third party, the liability is not limited to that party that you had a contract with, specifically the dealership. Anybody in the chain of the manufacturer may have liability, including the manufacturer, Ford, the distributor, perhaps there's a wholesaler involved, perhaps Ford manufactures the car, but there's components of the car, such as the wheels or the brakes that are manufactured by some other entity. So the point is that just because you don't have a contract with anybody other than the dealer doesn't serve to absolve them from liability in the event of an injury to a third party. Now, one of the issues relevant to the Brown case was the interpretation of comment C to restatement section 385. And another long section, but essentially what this section says is that with regard to what we just talked about, that you're not limited to liability just because you don't have a contract. If the contractor who turns over the land with knowledge that the work has made it dangerous and is unlikely to be discovered by the possessor is subject to liability both to the possessor and to those who come upon the land with the consent of the possessor or who are likely to be in its vicinity. So what this means is that if the contractor performs work that's defective and that defect is latent or unlikely to be discovered by the owner, what this means is that the contractor is subject to liability both to the owner and to third parties who enter on the land or are likely to be in the vicinity of the land. So going back to the window example, the contractor installs the windows defectively and the owner is unlikely to discover it. The contractor is subject to liability both to the owner and to any third parties in the vicinity of the window that are injured. But the question that the courts were faced with was whether the mention of this liability to the owner means that if the defect is known to the owner, does this mean that the contractor is not liable to third parties? And up until this case, Brown, there was a difference of opinion. The Commonwealth Court said, yes, it doesn't matter. The Superior Court, the other intermediate appellate court in Pennsylvania, said, no, said if the owner's aware of the defects, the contractor's off the hook, no liability to the contractor. So what the Supreme Court did in Brown was sort of resolve this dispute, a differing of opinion between the intermediate appellate courts in Pennsylvania. So we have the two different interpretations on this slide. Mr. Brown was endorsing the Commonwealth Court decision that a contractor who turns over work is liable for the defect regardless of its knowledge or awareness of the defect. Whereas the contractors, the contractor and the architect, were of the mindset that the Superior Court's interpretation in a case called Gressick versus PA Partner should apply. And that case, the Superior Court held that a contractor turns over the work is only liable if the defect is unknown to the owner. And Gressick was a case involving a steel manufacturing plant where the prior owner of the plant had hired a contractor to remove a drawbridge, and the drawbridge was to be used to escape should the molten steel breach the side of the furnace. At some point, this drawbridge was removed. The property was then sold. The new owner was aware that the bridge had been removed, didn't do anything to put the bridge back. And inevitably, there was a breach of the side of the furnace. Somebody was severely injured and sought to impose liability against the owner as well as the contractor. Superior Court said, no, the contractor's off the hook because the owner was aware of the condition, and that awareness and knowledge immunized the contractor from recovery. So that was the state of the law coming into Brown. So then we get to the actual decision. The court placed heavy emphasis on that final clause of restatement section 385. That's the one we talked about just a little bit earlier, that contractors are held liable under the same rules as those determining the liability of one who, as a manufacturer independent contractor, makes a chattel for the use of others. And that's where the car example, the liability is not limited to the dealer, but is also limited to others on the chain, even though they're not in direct contract with the owner. So the court went through a little bit of history here. Historically speaking, contractors are only liable to those in privity of contract. So the contractor, because it has no contract with a third party who happens to be injured by its work, isn't liable to that third party, but only to the owner with whom it has a contract. 1916, there's a famous case out of the New York Court of Appeals, Judge Cardozo, who's a well-known judge in the legal history. He was later a United States Supreme Court justice. The case, and this was a car case, and this is sort of where I drew that example. There's a case called McPherson versus Buick Motors, where somebody purchases a car, the wheel's defective, causes the car to collapse, and the plaintiff brings a lawsuit against Buick, brings a lawsuit against the manufacturer of the wheels. And at the time, it was held that the prevailing view was, well, there's no contract with Buick or with the manufacturer of the wheels, so you're out of luck. But that case extended liability, discarding the privity of contract requirement, and held that anybody involved in the chain of production who contributed to the defective chattel or car could be held liable. In Pennsylvania, Pennsylvania adopted that particular viewpoint with respect to contractors starting in 1949 when it adopted the Section 385 of the Restatement of Torts, which is what we went through before. The court went through an analysis and found that under a plain reading of the sections discussing liability, there was no exemption for an out-of-possession contractor where the dangerous or defective condition was known to everyone. Specifically, the court quoted a 1963 case which stood for the proposition that contractor can't plead immunity from liability for resulting damage on the basis that the responsibility ceased with the insertion of the last bolt and the driving of the final nail. And while that's a good soundbite, all that means is that just because you finished the work and turned over the work doesn't mean that you can no longer have liability. So what's the result here? As I said previously, the city settled earlier on in the litigation for the $500,000. So the city was not insulated from liability just because the contractor's work was defective, but likewise that the city was liable and paid $500,000 didn't in and of itself serve to insulate the contractors from liability. Now, importantly, the Supreme Court made no factual findings. That is, the Supreme Court did not determine that the contractor or the architect was ultimately liable, just that the owner's knowledge in and of itself did not serve to shield the contractors from liability. And essentially what this decision does is it eliminates the distinction whether the defect in the work is known and obvious or patent or unknown and hidden, latent. So regardless of whether the defect is known or unknown, as a result of the decision in Brown, the contractor could face liability. So what are the takeaways here? First of all, it's a highly unusual circumstance, right? The owner became aware of the defects almost immediately. The owner informed the contractor, but decided not to take any action. In most circumstances, either the owner doesn't know of the defect until there's an injury, or the owner knows of the defect and says to the contractor, hey, get out here and fix it. This is your responsibility. If somebody's injured, you're going to be on the hook. So you better get out here and fix it as soon as possible. But for whatever reason here, that wasn't done. But regardless of the highly unusual circumstance where everyone's aware of the defect and nothing happens, contractors still need to be aware of how to best insulate themselves from risks to prevent them from being the next Fred Burns type contractor. And how do we do that? How do we avoid liability for defects in work that's known to the owner and the owner doesn't do anything as far as correcting? Well, the first thing is can be done during contract negotiation. If you have existing contracts, form type of contracts, probably want to review them. Make sure they are adequately protected. In a contract with the owner, contractors should include terms that require the owner to defend and indemnify the contractor for third-party claims due to defects that the owner is aware of, but neither one notifies the contractor or two doesn't give the contractor the opportunity to correct. So if an owner finds out about a condition, defect in the work, hey, we noticed this window in this high rise, it's doesn't look like it's it's being held in, looks like it might fall onto the street below, and withholds that information from the contractor, well, you don't want to be held responsible for that, because while it's a condition the contractor may have created, the owner withheld the information that the work was defective and posed a risk to third parties. But the other implication here is if the owner notifies the contractor, but tells the contractor, well, we're aware of this condition, but don't worry about it. We don't want you to correct it. Contractor doesn't want to be held responsible in that situation, because obviously a contractor can't come onto an owner's land and correct work absent the owner's agreement to allow them to do so. So one of the key provisions to try and include in contracts is a defense and indemnification obligations. If there's a defect the owner's aware of, neither notifies you as the contractor, or if it notifies you, doesn't give you the opportunity to correct. So then we have the scenario post-construction. The owner does reach out to the contractor to notify you of reported defect in the work. Well, what do you do? Well, you can either do nothing, like in Brown, don't recommend that, or start a dialogue with the owner. The owner makes you aware of defects. You should make an effort to come out and correct the work. Should request an opportunity to visit the site, assess the defective work, and determine what, if any, corrective work's required. Could be that the owner sees something it thinks is defective, but upon further review, it's not a defect at all. But if defective work, if the inspection results in a conclusion that there's defective work, you need to determine what corrective work is required. And once you do so, you want to make an offer in writing to perform this work. This is good evidence later on if there's a contention that the contractor is responsible for injuries to a third party. Because if the owner says, I'm aware of this risk, I don't want you coming on my property to correct the work, then you can put the owner on further written notice that, okay, you can go in this direction, but we're not going to assume any liability for injuries to third parties, and we expect defense and indemnification. Once the owner receives that, the owner can either say, okay, I'm good with that, or the owner can take issue with that and come up with a solution to address the problem to minimize the risk to everybody. But the important point here is to make sure that everything is well documented so that if there's later an injury to a third party and a lawsuit, that you have a defense as a contractor to liability. Also, if you're made aware of this condition, this is a defective condition that might cause injuries to third parties. You probably want to put your CGL carrier on notice because there may be coverage in the event of an injury. So there's a few issues that are pertinent here, but the court in Brown didn't really address. First is a concept known as the statute of repose. And, I know that I was under the impression that some contractors may not be aware of the statute of repose, but then in speaking with John at the last meeting, John was fully familiar with the statute of repose. So perhaps it's not as far in a concept as I had thought. But essentially what the statute of repose is that if there's a defective condition in the work, that condition has to present itself within a certain period of time. Otherwise, there's no liability as against the contractor. Another way of saying that is if a contractor builds something, for instance, taking the Oil City case, if the original stairs had collapsed and caused injury to a third party, the contractor that constructed the stairs back in 1904 or whenever wouldn't be held responsible because that's just ordinary wear and tear. A contractor doesn't guarantee its work indefinitely. In Pennsylvania, the defect has to present itself within 12 years. So if Fred Burns completed those steps at the end of 2011, we get to January 2024, there's a defective, there's cracks in the stairs and a third party falls. Well, Fred Burns is off the hook because more than 12 years has gone by since the construction was completed. In Pennsylvania, a contractor can face liability for up to 14 years if the condition presents itself between 10 and 12 years after completion. The plaintiff has up to 14 years to commence a cause of action, but the condition itself has to exist within 12 years. Statute of repose is different from a statute of limitations. Statute of limitations just refers to how long a plaintiff has to file a lawsuit after its injury, whereas a statute of repose limits the length of time that can go by after completion of construction before the injury occurs. And there is a push because 12 years is one of the longer statute of repose in the United States. For instance, New Jersey's is 10 years, Delaware, 6 years, Virginia's 5 years. On the other hand, Maryland is 20 years, but there's a push in Pennsylvania to reduce the statute of repose from the existing 12 years down to 6 years. It was introduced most recently as Senate Bill 336 in the Pennsylvania Senate. We've been monitoring it, but it looks like hasn't really moved forward. There was a similar bill introduced in the last legislative session that also stalled in the Judiciary Committee and never really advanced. But that's something we're continuing to monitor. But as of right now, the statute of repose remains at 12 years. So any defect in the work, if it presents itself within 12 years, there's potential liability to the contractor that installed it. And here, obviously, that wasn't at issue because the defect in the work pretty much presented itself almost immediately after the construction was completed. The other issues not addressed in Brown, but can be of importance, is the apportionment of liability. Well, what does that mean? Well, here in Brown, it did come up to a certain degree because we're dealing with multiple parties. And the contractor, the architect, the owner were all alleged to be liable. Obviously, we don't know who was 100% liable, who was 0% liable, or anywhere in between. But oftentimes this comes up because, generally speaking, if you're a plaintiff, a person injured is more than 50% responsible for its own injuries, well, then recovery against anybody is barred. So that wasn't alleged in this case, but imagine the scenario where, say, Mrs. Brown wasn't just walking down the steps and encountered a dangerous condition of which the public wasn't notified, but say the area were cordoned off. There was tape around it saying "Do not enter." But the plaintiff thought it was an easier way to get down the stairs and having to walk all the way around, and just quick. It didn't look too dangerous, so decided to proceed in spite of the risk. Well, that might impute some liability onto the plaintiff. It might even make the plaintiff more than 50% liable, which would serve to bar any recovery as against the contractor. It's also possible that the owner can be mostly liable. If, for instance, here, regarding the concrete steps, there's no allegation as to what the owner did or didn't do to cause the condition other than doing nothing to get it corrected. But the longer the owner is in control of the property, the more opportunity the owner has to contribute to a condition causing a risk of injury. For instance, concrete steps. The owner applies some chemicals to the steps to help melt ice. That can cause cracks in the concrete. So these are all factual issues that are unique to every type of case. But the point is that just because there's potential liability to the contractor, if the owner is aware of the condition, it doesn't necessarily mean that the contractor will be liable, meaning that the contractor still has whatever defenses it otherwise would have had, including statute of repose, which we just discussed, comparative liability. The plaintiff might be at fault for most, all or part of most of its injuries, or another party might be responsible for part or all of the injuries. Now, this is somewhat of a recent development in Pennsylvania law. In 2011, there was a change to the traditional scheme of joint and several liability. And joint and several liability is just sort of a fancy way of saying that where there are multiple defendants, and there's recovery against multiple defendants, a plaintiff can recover all of its damages against any of the defendants. So say you have the scenario where the contractor, the architect, structural engineer are each 1/3 liable. Under a traditional joint and several liability scheme, the plaintiff isn't limited to 1/3 recovery of its damages against each, but it can seek 100% of its damages against any of them. Now, in 2011, Pennsylvania passed what's called the Fair Share Act. And that says where recovery is allowed against more than one person, and that's what I was just talking about with the joint and several liability, each defendant shall be liable for that proportion of the total dollar amount awarded as damages in the ratio of the amount of that defendant's liability to the amount of liability attributed to all defendants and other persons whom liability is apportioned. And essentially what that means is that's an effort to limit liability on a percentage basis. So if you're 1% liable, you're not going to be on the hook for 100% of the damages. However, as interpreted, well, before we get there, the Fair Share Act doesn't eliminate joint and several liability in its entirety. And importantly, it only limits joint and several liability where a defendant is less than 60% liable of the total, 60% liable for the total. So for instance, if a defendant is only 1/3 liable, well, under this statute, they'd only be responsible for 1/3 of the damages. However, recent Pennsylvania appellate decisions, the Superior Court has limited application of this 60% threshold to where there is also comparative liability of the plaintiff. And that was a case called Spencer versus Johnson, a 2021 Superior Court case in which a pedestrian was hit by a drunk driver, and the court held that traditional joint and several liability applied because there was no allegation that the plaintiff, the pedestrian lawfully crossing the street, was in any way responsible for her own injuries. So this is an area that's still a little bit in flux. Intuitively, that's probably the wrong result, because the intent of the Comparative Share Act is that not to impose 100% liability for a defendant who's only minimally responsible for the injuries. But for the time being, absent some finding that the plaintiff is in some way responsible for his or her own injuries, there is a risk that a defendant, a contractor, could be responsible for paying 100% of the damages, even though it's not at least 60% responsible. But that's another area that there's sort of minimal case law, and it remains in flux, and we'll also continue to monitor to see if the Supreme Court at some point interprets the language of the Fair Share Act to limit liability to just the fair share if less than 60% responsible for the injuries. So what are the conclusions here? Certainly stay on top of a disinterested owner if you know there's an issue with your completed work on a project, you're made aware of defects and nobody's begging you to come out there to complete it. Because based on Brown, knowledge and lack of action from an owner once the work is turned over will not serve to insulate the contractor from liability. As always, and this is our recommendation, my recommendation to anything is to keep a record, keep a written record, have evidence that if you find yourself in litigation, it will be useful. You want that written notice that you're ready, willing, and able to come out there to correct the defective work. You want written notice, making clear that you're not going to be held responsible if the owner insists on not allowing you to come out there to complete the work, and also notify your insurance carrier to get coverage that way. There's a lot of issues to address, considerations, defenses to liability, but it's important to address defects in the work before they result in injury to third parties. Had that happened in Brown, well, this case never would have happened. The contractors would have fixed the work. Mrs. Brown would presumably still be alive, and there would be no lawsuit and potential liability against the contractor, the architect, or the owner. I would, should these issues come up, and you want to consider ways to protect yourself from liability, my contact me or any of my colleagues here at Cohen Seglias. We're very well versed in all these areas of construction litigation. And we'll do everything in our power to guide you and to protect your interests. Thank you.
Thank you, Matt. Thank you. Any questions or so? I did get one text here.
All right.
Say this happened in 2025 after the statute of repose had expired.
Right.
This would be a non-issue then, correct? Or
that's true. Unlike a statute of limitations, which is a waivable defense, if statute of limitations, if somebody gets injured today and they want to bring a negligence claim, they have 2 years from their injury to bring the claim. But if a defendant decides not to raise the issue for whatever reason, they can be deemed to have waived it. Statute of repose in Pennsylvania is sort of an absolute bar. It's not a waivable defense. It can be raised at any time. So, unless somebody completely ignores the issue, which I don't expect, if it happened in 2025, the plaintiff would generally be out of luck, at least as it pertains to the contractor. If we're perhaps the owner, right? If the owner became aware the condition was defective in 2025 and decided, well, we're aware of this condition, but it's too expensive to correct. Let's just wait and see what happens. Well, then that's a different issue. But as it pertains to the contractor's work, the passage of 12 years would serve to preclude any claim of negligent construction against the contractor.
yeah, I don't want to read into this, but I think the question was kind of, okay, the owner construction team knew about the incident prior to 2025. Just like this case happened, but the incident didn't happen until.
Yeah, sure.
Pass a statement of purpose.
Yeah, and it doesn't really matter because,
Right.
I don't know exactly what happened here, but, certainly that's a potential way of proceeding, right? The owner becomes aware of the issue, notifies the contractor. The risk of something catastrophic happening is relatively low, and the owner says, "Well, why don't we just take our chances and see what happens?" If 12 years goes by and nobody's injured, well, then you're just talking ordinary wear and tear, and uh, there's no liability against the contractor for the injury.
So I have a question.
Yeah, sure, Seth.
So say you have a window
Yep.
and the manufacturer that I'm the contractor, and the manufacturer that I bought the window off of guarantees it for 6 years.
Right.
And I install it, but now I'm obligated to say, hey, I got to guarantee this for 12 years because of the law.
Right.
That doesn't make sense to me. Because
Yeah.
the window will only last 6 years, but then it breaks year 7. The law says it broke and it fell and hurt somebody after it was limited to 6 years. At the 7th year, it wear and tear, the guarantee was off. It fell out, hurt somebody, and now I'm still in trouble, right?
Potentially, yes. And there's certain ways to limit this, at least with respect to the contractor and the owner. Now, a contractor can always negotiate with the owner that any claims, well, actually, it's usually the other way around. But no, it's not. A contractor can negotiate with the owner that any claims for defective work, any claims arising out of the work shall be deemed to have accrued no later than the date of substantial completion. That used to be in older versions of the some of the standard form AIA contracts, that language was in there, such that if there was a claim for breach of contract or negligence, that claim was deemed to have accrued once the work was completed. I think the current AIA contract says 10 years from substantial completion. But regardless, that doesn't insulate you from liability as against third parties because they're obviously not a party to that contract. If this is an issue, again, it's something that could be negotiated with the owner, right? If the manufacturer is only giving you a 6-year guarantee on these windows, the owner is comfortable with that 6-year guarantee, well, then you want to put in that contract that if there's an injury to a third party after that guarantee period, that you're not assuming liability for it. So, I mean, that's the best way to handle that. Whether an owner is agreeable to that or not is a different question. But certainly, because the third party is not a party to the contract, you can't really do it contractually, unfortunately. But the best you can do is try and limit your risk exposure by negotiating the terms of your contract with the owner.
Thank you.
Welcome. And then one more here I had was I recalled reading it or hearing about it that the contractor Fred Burns, maybe I'm confusing my cases here, my projects, but I thought I read somewhere that he never collected his retention on the project.
I think that's right.
Did that play a factor at all in the judgment, or?
I don't
know how it could, but
to be clear, there wasn't a judgment. It was just that the Supreme Court sent it back to the trial court to presumably have the case proceed to trial. But certainly, I'm assuming that would be a factor. If the owner never closed out the project because of defects in the work, then that would give more credence to the contractor potentially being on the hook because they haven't been paid in full and the owner never accepted it. But as far as I'm aware, at least in the Supreme Court opinion, and I don't believe in the Commonwealth Court or the trial level opinion, there was really much focus on the fact that the retainage wasn't paid.
Yeah, to me, it just seemed like it kept it open a little bit and perhaps was held on to because the defect wasn't corrected, but I'm just assuming that. I don't know.
Yeah, I think that's, a fairly safe assumption that everyone's aware of these defects in the work. They're not paying the retainage, but for whatever reason, nobody's doing anything about them. Which is why, as a practical matter, the facts of the case are rather unique, and I don't see this playing out, on a particularly often, right?
Yeah.
So that's why, every case is decided on its own facts, but these facts are probably unlikely to repeat themselves, particularly now that we know that the contractor can be liable if there's an injury, but everyone's aware of it. I mean, just the point is that the contractors will now want to put increased pressure on the owner to get this work corrected before it causes an injury to a third party.
Yeah, agreed. It's a very unique case, and so but ramifications from it, could affect a lot of other contractors. So.
Oh, absolutely, and that's why I provided those sort of recommendations of what you can do pre-contract, post-contract once you become aware of the issue, just so you don't find yourself as the next Fred Burns and potentially facing liability for a condition that everyone's aware of.
Yeah. According to records, Fred Burns was a KCA member back in the 70s or so, so I didn't know he was still around. So,
Yeah, well,
there you go.
well, look, even the best contractors can have these issues pop up. So,
Yeah.
I mean, that's why it's important to protect yourself so that it doesn't get to that point.
Absolutely. Yeah, well, hearing no more questions, just on behalf of the KCA, want to thank you, and we'll make sure to send your contact information out, so if people want to follow up with you, that can happen.
Yeah. Thank you, John and Seth, for giving me the opportunity to speak on this case. And certainly, as I said, either me or any of my colleagues here at Cohen Seglias deal with these types of issues of liability and contractor liability, third parties, routinely, and we'd be more than willing to assist.
Awesome. Well, thanks.
All right. Thank you.
Thanks, and yep, I'll see you at the next event.
Yes. See you then.
All right, take care.